The Arizona Foundation for Legal Services and Education is proud to support the Never Again Foundation in bringing you the Arizona Crime Victims' Rights Program. If you or someone you love has ever been the victim of a crime, watching this program may be the most important thing you do today.
Hi, I'm Lynn Sucuni. Welcome to the Arizona Crime Victims' Rights Program. This program is an overview of how our justice system works. We'll also share some of the free resources that are available to help those hurt by crime and the basic rights you have if you are ever a victim of crime in Arizona.
Our nation was founded upon the belief that we are endowed with the inalienable rights of life, liberty, and the pursuit of happiness. As Americans, we believe that one of our greatest gifts is our freedom. This is the reason that from the very beginning of our nation, a defendant accused of a crime is provided constitutional rights protecting this freedom until proven guilty. However, innocent victims of those crimes did not always receive attention to their concerns. So in 1990, the voters in Arizona enacted into our state constitution fundamental rights protecting crime victims.
In 1990, Arizona voters took a major step in recognizing the rights of crime victims and established this state as a national leader in that area, basically saying that if you had been the victim of a crime, you had specific rights to appear in court, to be involved in the prosecution, and to be treated in a special way, which certainly had not been the case before.
The American court system is complicated and can sometimes feel overwhelming, even for experts working in the court system. But an easy way to better understand how our legal system works to protect victims of crime was developed by the Never Again Foundation. Its innovative three doors approach helps to reduce frustrations for victims of crime.
One of the simple keys to better understanding our legal system is to think of it as that there are three different doors. Door number one would be the criminal system, door number two would be the civil system, and door number three would be the family court system. Now, each one of these doors have different powers and different remedies that can offer a victim of crime. And so the key to really remember is what remedy do you need in your case, and then go to the right door or to the right series of doors to get it.
There are three different legal systems, or doors, available. We'll begin at door number one, the criminal justice system. The criminal justice system is designed to keep in balance the rights of society, the rights of all of us to be free from dangerous people, from criminal attack, and at the same time to protect the rights of the innocent and the rights of the accused. During criminal prosecution, the victim of a crime is the primary witness and serves that part of the legal team in proving the guilt of the defendant. However, the victim does not have primary control over what happens. That responsibility is left to the prosecutor.
Right, the prosecutor in Arizona, the prosecutor of felonies, is the county attorney, represents the people. And the prosecutor goes into court to seek justice on behalf of the people of, in my case, Maricopa County, and through them the state of Arizona. And so our mission is to seek justice in these criminal cases that come to us. And victims and other people may have their own attorneys who can become a part of the criminal justice process, but I am not their attorney for purposes of prosecuting a criminal case.
And that always is a little bit difficult for victims to understand, because we develop very close relationships, we work very closely together. You know, if it weren't for victims coming forward and testifying and being absolutely willing to tell their story in the courtroom, I wouldn't be able to do my job. There'd be no way I could go forward on a case without the help of victims.
When deciding whether to pursue a case, the prosecutor will be required to evaluate the strength of the evidence and the likelihood of successfully obtaining a criminal conviction. Three important concepts will be considered. First, the burden of proof. Second, the possibility of plea bargains. And third, the statute of limitations.
In the criminal justice system, the burden of proof that the state has to fulfill is beyond a reasonable doubt. That is the highest level of burden of proof that exists in our legal system.
You can't ever eradicate all doubt in anybody's mind. I don't know that there's much in life that you can prove beyond any doubt whatsoever. but that the jurors have to be satisfied in a case that it's more reasonable than not that the evidence shows that this person committed the crime, that they shouldn't have significant doubts about whether the crime was committed by that person or not.
The fact that we have this reasonable doubt standard, that a defendant has to be shown guilty beyond a reasonable doubt, shows just how deeply Americans believe that the liberty of a person or the life of a person should be protected, and the standard should be very high that the state has to meet in trying to deprive a person through the criminal justice system of their liberty, of their property in the cases of fines, or in some certain cases of their very lives in certain capital first-degree murder cases.
The prosecutor's primary responsibility is to protect the best interest of society. Their job is to successfully prosecute as many cases as possible with the limited resources and manpower they possess. Prosecutors are often faced with tough cases and too many of them to be able to take them all to trial. This leads to the practice of plea bargaining.
Plea bargaining or plea negotiation is the process whereby the state and the criminal defendant try to reach an agreement to resolve a criminal case. The state and the defendant will enter into a plea agreement that agrees generally that the state will dismiss certain criminal charges, and in exchange the defendant pleads guilty to certain criminal charges. What the state gets out of a plea agreement is the certainty that a defendant will be found guilty of some crime and will receive some punishment for that criminal offense. The criminal punishment is ultimately up to the court to decide. What the defendant receives is, in most cases, the dismissal of certain criminal charges or counts by the state in exchange for agreeing to plead guilty to those other crimes. And what the victim receives from a plea agreement is the finality of the case, knowing that the defendant is going to be found guilty of something, will be punished in some way, will receive restitution.
Even if the evidence is overwhelming and the case is strong, the law also requires that a case must be prosecuted within a certain limited window of time after the crime was committed. This is called a statute of limitation.
From the time that it's committed to the time that it's filed in court, we only have a certain amount of time in which to make that formal accusation. And it depends upon the nature of the offense and how serious it is as to exactly what that statute of limitations is going to be. So for instance, if you commit a minor misdemeanor like shoplifting, the prosecutor has 1 year from the time that that offense was committed to bring that charge in court against somebody. If it is a more serious crime, most felonies have a statute of limitation of around 7 years. But then if it's a very serious crime, the most serious, murder, there's absolutely no statute of limitations whatsoever. And that's because society has said it's more important to be able to hold somebody who takes someone's life accountable than to file charges against somebody who commits a minor assault.
Sometimes crimes leave victims financially devastated. While the criminal system is not primarily designed to make the victim financially whole again, there are two important rights that you should be aware of that can financially help the victim as part of the criminal system: criminal restitution and the Crime Victims Compensation Fund.
You have a restitution is your right as a crime victim under Arizona's Bill of Rights for victims, and you're able to just participate on the criminal side and obtain restitution that way.
Property damage, physical damage, or has some specific out-of-pocket expenses that they've incurred as a result of the crime, then the person who is accused and held accountable, convicted, the defendant, is required to repay that to the victim, to restore them back to some state of near wholeness with regards to their economic losses. It only deals with economic losses, although it can also cover things like counseling expenses, etc. The court orders it from the defendant, and it's something the defendant is required to pay. However, there's also a mechanism in the law called a restitution lien. And if the victim if the defendant has any property, or like a car or a house or anything significant, we can put a lien on that property and sell that property in order to get the money to pay the restitution to the victim. So there are some mechanisms and some means by which the victim can get some of their losses back.
Well, the Crime Victim Compensation Fund is a program that assists innocent victims of crime in Arizona with out-of-pocket expenses for crime-related medical treatment, mental health counseling, funerals, and wage loss. In order to be eligible, you must be a victim of crime in Arizona. You must report the crime to the police within 72 hours, apply for these funds within 2 years of the crime, and willingly cooperate with law enforcement. You may also be eligible for victim compensation even if an offender is never arrested, tried, or convicted. For more information, contact the Victim Compensation Program Manager in your county. Generally, victims do not know about the Crime Victim Compensation Program, or they oftentimes confuse it with restitution. Restitution requires a conviction of an offender, whereas victim compensation, it does not matter whether there's an offender caught or tried or convicted.
Nearly 2 decades ago, the Arizona State Legislature enacted the Crime Victims Bill of Rights. Still, most Arizonans, and most importantly, most victims of crime, don't know what their rights are.
It's important for people to know their rights under Arizona's Constitution if they become a crime victim, because then they can play an active part in the process. They can confer with prosecutors before a plea agreement is reached. They are allowed to speak to a judge before sentencing so that the judge knows the true impact of the crime and how it has affected the crime victim and their family. And it is so very much important to be treated with dignity and respect in the process, because for many, many years, victims were not a part of our criminal justice process. Crime victims were an afterthought in Arizona until 1990, when we passed our Crime Victim Bill of Rights. The most important right that's afforded crime victims in Arizona's Constitution is the global right to be treated with fairness, respect, and dignity from every player in the justice system throughout the entire process, from the time of the crime until the time of the release of an offender from custody.
Before charges can be brought, before a trial can begin, it's the role of law enforcement to begin the legal process. And here too, crime victims in Arizona have rights.
Depending on where the crime occurs will depend on who investigates it, whether it's a city police department, the sheriff's office, or the State Department of Public Safety. Will depend on who investigates it. When the officer is investigating it, the officer's going to look at things such as who, why, when, where, and how. And those elements should be included in the report. Statements, the crime scene, any evidence that is found. Even the, things such as what's the weather condition. Things like that will be included in the report. Officer will prepare that report. Report will be filed with, obviously, his or her agency, and the report will be sent to the county attorney for review for criminal charges being filed. Now, a victim is entitled to a copy of the report, and they can get a copy of the report from the agency by going through the custodian of records. Now, normally there'll be a small fee for reproducing the report charged to the individual.
When victims first enter the legal system, they are given a sheet of paper. This sheet of paper notifies them of exactly what their rights are. When a crime happens, victims hear a lot of information, and it's very hard to process it all at once. That sheet is always something you can count on. It includes a list of resources available to you, county and city attorney numbers, victim assistance numbers, and other healthcare related issues that may surface with becoming a victim. Many prosecutors' offices throughout Arizona also provide special victims advocate counselors to help support crime victims throughout the criminal process.
Law enforcement officers in Arizona are required to provide victims' rights to every crime victim for any crime that occurs in the state of Arizona. If they do not receive the rights from law enforcement, they need to call the Attorney General's office, and we will make sure that they are fully aware of what their rights are and how they can participate in the process.
The criminal justice system, or door number 1, is designed to protect all of us in society. As a victim of crime, you have many important rights.
You have the right to be treated with fairness, dignity and respect by everyone in the criminal justice system through every step of the process.
As the victim of a crime, you have the right to be informed of any plea offer that is made to a criminal defendant. You have the right to a speedy trial. You have the right to restitution, in many cases, for money damages suffered as a result of a crime. You have the right to be informed of the sentence that is imposed on a criminal defendant and to make a statement regarding that sentence.
You have the right to obtain a copy of the police report.
You have the right to apply for crime victim compensation benefits if you are a victim of crime in Arizona.
As a victim, you have the right to have your voice heard in the courtroom. You have the right to speak to the prosecutor about your case. You have the right to give your input regarding a plea. You have the right to speak at sentencing and to talk to the judge. You have all of those rights as a victim.
Along with legal rights in the criminal justice system, you also have many important legal rights available to you behind other doors. Let's go now to door number 2, the civil justice system.
Well, door number 2, the civil system, by constitutional design, is designed to take care of the remedies for a crime victim that they cannot get under the criminal system. The number one thing that people think about is the money. Well, the civil system does do that. It tries to understand the full impact of all of the damages that a victim of crime went through and hold the perpetrator accountable for that. But the civil system goes beyond much further than that. Perhaps the thing that is most important to many victims of crime is a sense and a feeling of justice. A victim of crime can receive tremendous amount of benefits through the civil system because it is designed, this is the system that is designed around their needs and wants. It's trying to put them back into the position they should have been in had the crime never occurred. This is the system where they have a lawyer who is their lawyer, representing them and their needs and wants.
Because of different standards of proof, a victim may be able to obtain a sense of justice and accountability from a defendant through a successful civil verdict in door number 2, even if the criminal process of door number 1 was unsuccessful.
The burden of proof is how much evidence we have to have in order to win our case. And that burden of proof is actually different between the criminal system and the civil system. The criminal system has a much higher burden of proof. The civil system is by a preponderance of the evidence, or more likely than not. That's a much easier standard to meet than the criminal system is. So the outcome of that is we might be able to have a successful case in the civil system regardless of whether or not there was a criminal conviction in the criminal case.
The civil justice system also has statutes of limitation that require victims to file their claim against the perpetrator within a certain window of time or otherwise lose this right.
Well, the civil system also has a statute of limitations like the criminal system does, but it's different. The civil statute of limitations typically is 2 years from the date that the crime occurred, or at least that the victim found out who the criminal was. And that can be different from this criminal statute of limitations. So they're not necessarily going to be the same statutes of limitations for the same incident. The criminal statute of limitations for the same incident can be different than the civil statute of limitations.
To better protect crime victims, Arizona recently enacted a new law that gives crime victims, in some situations, an even longer statute of limitations. If the prosecutor has filed charges against the defendant, the victim, with this new law, can now take up to 1 year after the prosecution is done, the criminal prosecution is done, to file the civil lawsuit against that defendant. This law applies regardless of how long the criminal prosecution takes or whether the criminal prosecution was successful.
Crime victims lose so much. The pain, the fear, it cannot be measured. In financial terms, we all pay for the crimes committed. There are only 3 parties that can pay this staggering bill: the criminals who cause it, the victims of their crime, or the rest of us in society. The civil justice system is designed to send the bill back to those who caused the harm, back to the perpetrators. Holding a defendant financially accountable through the civil justice system is different from restitution available through the criminal justice system. Typically, civil compensation is much, much more than criminal restitution.
A judge in a criminal case will award restitution to a crime victim to cover their actual losses involved with the loss of property or perhaps some medical bills. But this in no way comes close to covering the type of emotional trauma that can occur because of a crime. And the civil system allows victims to be made whole, to get the coverage for the long-term therapeutic care that they need, to make the offender accountable in more than just a sentence of jail, prison time, or probation.
Through the civil court system, victims can achieve a judgment against the defendant, which may be non-dischargeable in bankruptcy. The judgment remains the responsibility of the defendant, and if the defendant fails to pay that judgment off, that judgment will follow the defendant to their grave.
One of the outcomes of the civil system having a lower standard of proof is there's a special rule in certain situations called the disqualification of a killer as an heir. It typically comes up in the horrific domestic violence cases in which somebody was tragically killed. And this rule of disqualification of a killer as an heir means that the defendant is not allowed to profit financially from the crime. They can be prohibited from being able to receive life insurance benefits or proceeds, property, community property, other things through being heired that property. Now this is something that only happens in the civil system. It does not automatically happen as a result of any criminal conviction. But most importantly, this can happen in the civil system and they can be disqualified regardless of whether or not there was a conviction under the criminal system.
The civil justice system, or door number 2, is designed to protect us. As a victim of crime, you have many important rights.
You have the right to be fully compensated by the perpetrator for your injuries.
You have the right to have your civil statute of limitations, in some situations, extended up to 1 year after the final criminal prosecution is done, even if the defendant was not found guilty. You have the right to petition the legislature to change and improve laws that will better protect you.
There is a third legal door, the family court system. If a criminal act has occurred in a family-type setting, such as domestic violence, sexual assault, or child molestation, then door number 3 may also be necessary.
The primary issues we deal with are custody and parenting time, child support, spousal maintenance in appropriate cases, and division of marital property and allocation of community debt.
The family court deals with domestic violence cases, a heartbreaking problem in Arizona.
Well, the law is pretty specific, and it indicates that domestic violence is contrary to the best interest of a child. If domestic violence is present, the law prohibits joint custody from being awarded in that particular case.
Also, under a new Arizona law, crimes inflicted within marriage may cause an abusive spouse to forfeit their property in a divorce. In other words, a criminally convicted spouse risks losing in a divorce all of their community and separate property in order to pay the full damages their crimes caused to the victim's spouse.
An order of protection is an important legal determination issued for the safety of victims.
Order of protection is a court-ordered civil order which limits or protects the offender's contact with the victim. So it acts as an additional measure to safety for victims of domestic violence.
An order for protection can be issued by any court in Arizona, not just the Superior Court or the Family Court. It can be issued by a Justice of the Peace Court or a municipal court. And if there's domestic violence or domestic violence is threatened, a court can issue an order that protects a victim and the children of victims, who may also be victims, from domestic violence. They can restrict contact, give exclusive use of a home, can set conditions upon which someone can have access to the person that receives the order of protection and the children.
The family court system, or door number 3, is designed to protect the family.
You have the right to present evidence of domestic violence to the family law court. And if the evidence supports the remedy, you have the right to receive the benefit of those legal remedies.
You have the right to ask the courts for an order of protection to ensure your safety.
Associations and organizations throughout Arizona are dedicated to serving victims of crime.
Victims of crime often find that there's a domino effect in their life, that when one crisis happens, it leads to another in other areas of their life. We at the Foundation support our organizations that understand that one crisis can lead to another. and they are there to help with the legal services that you need in other parts of your life. We support excellent civil legal service organizations like the Never Again Foundation, Community Legal Services, DNA People's Legal Services, Southern Arizona Legal Aid, and many more legal agencies that have specialized legal help. If you have access to an internet and want the most up-to-date current information, go to azlawhelp.org and you can get the resources that you need. You'll be able to ask questions that you want answered, and you will know, most importantly, that you are not alone.
From the highest levels of law enforcement and government throughout all of Arizona, crime victims' rights have become a priority.
Depending upon individual circumstances, it is possible for a crime victim to be participating simultaneously in 3 doors to the justice system, entering the doors to the criminal, the civil, and the family court systems. It is important that victims understand what resources are available at each door, because the resources available to you in the criminal system may be different from those available in the civil or family court systems. Learning about and exercising your rights is the best way crime victims in Arizona can empower themselves.
We tend to use the word victim to describe those who have been injured in some way by a criminal act, because it's a word with which most people are familiar. However, victims of crime are really survivors. They're triumphant. While they may have been temporarily deprived of their right to be safe and secure, they can and do reclaim that freedom. We honor crime victim survivors for having refused to allow a horrific life experience to destroy that which is most precious, the enduring human spirit.
The 3 doors that you've learned about are the doors of hope, justice, and healing. I will continue to do everything in my power to make certain that every crime victim is treated with dignity and respect, and that Arizona becomes an even safer place for all its citizens.
If you or someone you know is a victim of crime, please feel free to contact any of the many services we'll list now, and know that there are legions of caring men and women here to help you.